You know, sometimes you come across a congressional hearing that instantly grabs your attention. I wasn't planning to spend much time watching this one, but after seeing a few clips, I realized there was a much bigger constitutional debate unfolding than I initially expected. Senator Ted Cruz wasn't just talking about Donald Trump. He was making a broader argument about presidential immunity, executive power, and whether the way former presidents are treated today could reshape the office for generations to come. As I watched the exchange, I found myself wondering whether this was simply another political back and forth or whether it raised questions that every American, regardless of party, should at least hear. So let's watch some of the key moments together and break down exactly what was said, what arguments were made, and why this hearing has generated so much discussion. Before we dive in, welcome to the Political Brief, your source for congressional hearings, political analysis, and the biggest stories coming out of Washington. If you enjoy in-depth coverage that goes beyond the headlines, be sure to subscribe, leave a like on this video, and join the conversation in the comments. Your perspective helps shape the discussions we have here, and I'd love to know where you stand after watching today's hearing. Now, let's get into the exchange.
Senator Cruz.
Thank you, Mr. Chairman. The nub of the Democrats' argument today is that the concept of presidential immunity is somehow unprecedented, is somehow remarkable. That claim is utterly ahistorical and disconnected from the entire constitutional history of the Republic. General Mukasey, before 2023, how many times has the President of the United States been indicted?
None.
Before 2023, how many times has a former President of the United States been indicted?
None.
In the last 2 years, how many times has President Donald J. Trump been indicted?
4 times, I believe.
Now, many presidents of both parties have engaged in controversial actions, and yet none of them have been indicted. Let me ask you, General Mukasey, if a private citizen were to erect an internment camp and to forcibly kidnap American citizens, to single them out because of race, and to imprison them based on their race, would that private citizen be subject to criminal prosecution?
Would.
When President Franklin Delano Roosevelt did the exact same thing and erected Japanese internment camps, was FDR prosecuted?
He was not.
Let me ask you, similarly, if a private citizen were, say, to detonate a nuclear weapon over a city and kill over 140,000 people, and then if that private citizen a few days later detonated another nuclear bomb over another city and killed 75,000 people, could that private citizen be criminally prosecuted?
He would.
Was President Harry Truman prosecuted for detonating nuclear weapons over Hiroshima and Nagasaki?
He was not.
All right, how about this? If a private citizen launched a weaponized drone and killed a United States citizen, could that private citizen be criminally prosecuted?
He would.
Was President Barack Obama criminally prosecuted when he killed United States citizens using drones without notice and without due process?
He was not. Although, as far as due process is concerned, I believe the comment of my successor to that question was that Anwar al-Awlaki got, quote, all the process that was necessary.
Well, although I suspect he might disagree with that assessment, were he able to present his case.
Right.
All right. Let's contrast that with the rules that govern other federal officials. You were a judge for 19 years. As a federal judge, did you have immunity from your official acts?
For my official act, yes.
Do federal prosecutors have immunity from their official acts?
They do.
Now, the distinction between official acts and personal acts is not a terribly shocking distinction. Under the decision of Trump versus United States, if any president walks onto the sidewalk and just shoots a citizen, is that president liable to be prosecuted?
He is.
How about this? If a president steals funds from his campaign, does that president face criminal liability?
He does.
How about this? if a president sexually assaults, let's say, an intern in the Oval Office, is the president subject to criminal prosecution for that?
He could be.
So that distinction, again, is not a shocking distinction. The Founding Fathers vested the executive power in a single president of the United States. What we have seen in the last 2 years is we have seen Democrats deliberately weaponizing the Department of Justice and our legal system to target their political opposition. It is not an accident that every indictment against President Trump was brought by a Democrat and was brought after he announced his campaign for President of the United States. Understand, the target of those indictments was not ultimately President Trump, it was the voters. It was prosecutors who were terrified that the voters would choose to re-elect President Trump. One of the great things about the United States is we're not a banana republic. Since 2000, the nation of Pakistan has had 6 former prime ministers prosecuted and convicted. Brazil has had 3 former presidents arrested and imprisoned. Last year, Nicaraguan President Daniel Ortega arrested, charged, and imprisoned 40 political opponents. General Mukasey, you were Attorney General of the United States. Is it the proper role of the Department of Justice to prosecute and target the political opponents of whoever happens to be President of the United States?
It is most assuredly not.
Thank you.
Senator Bowman.
One of the first things Senator Cruz points out is that, historically, no sitting or former U.S. president have been criminally indicted before the recent cases involving former President Donald Trump. He uses that as the foundation for his argument that the current situation is historically unique and deserves careful scrutiny. From there, Cruz begins asking Michael Mukasey about some of the most controversial decisions made by previous presidents throughout American history. He references Franklin Roosevelt's decision to authorize Japanese-American internment during World War II, Harry Truman's authorization of the atomic bombings of Hiroshima and Nagasaki, and Barack Obama's approval of a drone strike that killed American citizen Anwar al-Awlaki overseas. His question is straightforward. If an ordinary citizen committed actions like these, they would likely face criminal prosecution. Yet none of those presidents were prosecuted. Cruz argues that this demonstrates a long-standing understanding that presidents receive protection for official acts performed while carrying out their constitutional duties. Mukasey largely agrees with that historical observation. The discussion then shifts to what many legal experts consider one of the most important distinctions in the debate: the difference between official acts and personal conduct. Cruz asks whether a president would still face criminal liability for things like murder unrelated to official duties, stealing campaign funds, or committing sexual assault. Mukasey answers that those kinds of personal crimes could still be prosecuted. That's an important point because the conversation isn't simply about whether presidents can do anything they want. Instead, it's about where the legal line should be drawn between exercising presidential authority and committing private criminal acts. As the hearing continues, Cruz argues that allowing criminal prosecution for official presidential decisions could fundamentally change the presidency itself. His concern is that future presidents might hesitate to make difficult national security or military decisions if they believe they could later face criminal charges after leaving office. On the other hand, many legal scholars and prosecutors argue that no public official, including the president, is above the law and that criminal accountability is appropriate when there is evidence that laws have been broken. That's really where the heart of this debate lies. It's not simply about one individual or one election. It's about how much protection should exist for presidents performing their official responsibilities and where accountability should begin. Toward the end of the exchange, Cruz argues that the Department of Justice should never be used to target political opponents. Mukasey agrees with that principle, saying it would not be appropriate for the Justice Department to prosecute people because of politics. Of course, whether recent prosecutions meet that standard is itself a matter of intense public disagreement. prosecutors involved in those cases have consistently maintained that their decisions are based on evidence and applicable law rather than political affiliation. Regardless of where you stand politically, this hearing highlights questions that are likely to shape American politics for years to come. Should presidential immunity be broad enough to protect official decisions made in office? Or should former presidents be subject to criminal prosecution whenever there is sufficient evidence that laws were violated? Those aren't easy questions, and they're exactly the kinds of issues the courts, Congress, and the American public continue to debate. Now I want to hear from you. Do you think the current legal framework strikes the right balance between protecting the presidency and ensuring accountability? Or do you think changes are needed? Share your thoughts respectfully in the comments below. If you enjoyed this breakdown and want more coverage of congressional hearings, political debates, and major developments for Washington, don't forget to subscribe to The Political Brief. Leave a like if you found this analysis helpful, and turn on notifications so you won't miss future videos. Thanks for watching, and I'll see you in the next one.